Good morning. I have been told time and again that McDonough v. Rundle is the end-all and be-all of analysis for filming in a police station. This 11th Circuit Court of Appeals ruling gives you carte blanche to film in a police station. This has decided the First Amendment issues of whether or not you can film, and it has been cited to me over and over and over again, and I'm about done with it, so I am going to take about 5 minutes and break it down for you as to exactly why it doesn't apply to anything other than an analysis of Florida state law, specifically Florida state law statute 934.03. 934.03. That is all this decision applies to, and I am going to show you exactly why. And we're not even going to read the whole case to do it. Yes, I have read the whole case, but I do this to save you a little time and effort. You can read the case. I will obviously have it linked. You can do your best to try to point out to me exactly how I failed, but I don't think I failed, and you'll have a good time trying to argue it out with me. So we're going to read the introduction and the conclusion, and that's it. And from those, you will see exactly why I am right and everybody else is wrong. Plaintiff appellant James Eric McDonough. Plaintiff means that he filed the original suit as the plaintiff. In the civil suit, appellant means he lost and he is bringing the appeal. He's proceeding pro se. That means he doesn't have an attorney. That's usually a problem, but it worked out for him specifically in this instance. Appeals from a judgment of the United States District Court for the Southern District of Florida dismissing his complaint brought pursuant to 42 U.S.C. 1983. After McDonough lodged a series of complaints of misconduct against an officer of the Homestead Police Department, hereinafter referred to as the HPD, he was invited by Alexander E. Rolle Jr., the chief of police, Rolle Jr.? I don't know. To a meeting in his office to discuss the complaints. Unbeknownst to the chief, McDonough recorded a portion of the meeting on his cell phone and later posted portions of the recording on the internet. Shortly thereafter, he received a letter from defendant Catherine Fernandez Rundle, the Miami-Dade County State Attorney, informing him that his recording violated the Florida Security of Communications Act and that the violation was a felony. See Florida Stat 934.03. She forbade him from making future recordings and threatened him with a prosecution if he did so. Not a cool thing to do, but we're going to see whether or not she can do it. McDonough then sued her under 1983, alleging the statute did not apply to him, was facially unconstitutional, and that the threat of prosecution violated his First Amendment right to free speech. Now remember, he is the appellant. That means that he lost in the district court. The district court thought that it apparently did apply to him. It was facially constitutional, and that the threat of prosecution did not violate his First Amendment right to free speech. So keep that in mind. The parties cross-moved for summary judgment, and the court granted Rundle's motion. The court did not parse Section 934.03, assuming that it applied to the recording. Instead, it analyzed the recording under the First Amendment non-public forum principles because the recording took place in a police station. If you think that a police station is a public forum, if you think that it is a limited forum, if you think that it is a designated forum, you are wrong. Police stations are non-public forums. The court held that Section 934.03, as applied to McDonough, did not violate the First Amendment because it was reasonable and viewpoint neutral. If you remember our conversation this morning, a policy against photography or filming in a non-public forum has to be reasonable and viewpoint neutral. And denied McDonough's request for relief. He appeals and we reverse. We reverse? Oh boy, what does that mean? Well, here's what they held. We hold that McDonough did not violate Section 934.03, and consequently, the government's threatened prosecution has no basis in the law. Because we resolved this case under state law, we need not reach the constitutional issue of whether the recording is protected by the First Amendment. They don't even look at the First Amendment analysis. They say that the state law, Florida Statute 934.03, doesn't apply in these facts. They're not saying that the statute is unconstitutional. They're not saying anything about it. They're saying that under this fact pattern, Florida Statute Section 934.03 doesn't apply. You could see why I'm saying that this isn't a very broad decision. This applies specifically to Florida Statute 934.03 and this fact pattern. They're saying that the statute doesn't apply to this fact pattern. And then the conclusion. We hold that because the recording on February 7th, 2014 falls outside of the definition of oral communication in Section 934, McDonough did not violate the statute and it imposes no restriction on his use of the recording he made at the meeting. And it poses no restriction. The statute poses no restriction on the use of the recording he made at the meeting. It's very specific. It is specific to these fact patterns, to this statute. That's it. And so he didn't meet the elements of the crime because it wasn't an oral communication. He didn't meet the elements of the crime. Therefore, the statute doesn't apply. For the foregoing reason, the judgment of the district court is reversed and the matters remanded to the district court for further proceedings, if necessary, consistent with this opinion. Now, the dissenting judge, I think, has very good opinions that a federal court should not be interpreting state law like this, but they did it and it didn't make it anywhere to the Supreme Court, so there you go. It is a very limited ruling if you're dealing with recording in a police station and threatened prosecution under Section 934.03 of the Florida statutes. Then this case would entirely be on point. Otherwise, not so good. Anyway, I hope that makes sense. Thank you very much for watching and have a great day.